You know, the average amount of compensation for a clinical negligence claim is £30,000. Yes, £30,000. Want to know more? Well, stay tuned to find out more. Welcome to today's vlog on clinical negligence compensation claims. I'm Farouk Sheikh, the solicitor and principal at F.S Law Solicitors located in Chadderton, Manchester. Hope you guys are all doing well today. Right, so what's this clinical negligence compensation and what are we referring to? So essentially, clinical negligence compensation in a nutshell is where potentially a doctor, a nurse, midwife, consultant, surgeon, that sort of thing, anyone in the medical sector really, they owe you a duty of care. A duty of care to ensure the treatment provided to you is of a safe standard, of an adequate standard, and of course, by virtue of that, they owe you a duty of care when you seek medical attention from them. What can happen is there can be medical mistakes. Now, when we say medical mistakes, what medical mistakes am I referring to? So potentially there could be a misdiagnosis by your medical professional. So for example, it might be that you've been to see your GP and your GP has referred you, for instance, to the hospital because you have pain in a certain part of your body, say your arm, for instance. The hospital carry out an X-ray and it, as far as they're concerned, there is no fracture. It later transpires, many weeks later, many months later, that your arm starts to swell and of course it starts to get worse, the pain that is. You then go to a different hospital or a different department, for instance, at a different hospital, and have an X-ray taken, and it transpires that in actual fact, in retrospect, you did have a fracture and the initial hospital had made a mistake in diagnosing you not to have had a fracture. That would equate to potentially a breach of duty of care on the basis of a misdiagnosis, namely not a fracture, but in actual fact, you did have a fracture. Let's take another example. So potentially you have been to hospital, you are pregnant, and you have your routine scan. It then transpires that you are told that you sadly are having a failing pregnancy, regretfully and unfortunately. And then you are invited to take a tablet to abort the pregnancy due to it being a pregnancy which is failing as a result of a blood test being carried out and your hormone levels are dropping, for instance. However, after taking the tablet, say a few days later, you have another blood test and then it transpires that the blood test reading confirms your hormone levels are much higher, which means the initial blood test that was carried out was incorrect and factually wrong and erroneous. And based on that, clearly, you've now aborted your pregnancy on the basis of being told that it was a failing pregnancy, but in actual fact, it was not a failing pregnancy, and your second blood test has confirmed, quite rightly, that your hormone levels are much higher than what they had initially told you. As such, that would also potentially be classed and construed as a breach of duty of care by the hospital on the basis of the erroneous blood test results that have been provided to you. So I've given you a couple of examples as to breach of duty of care in the context of clinical negligence compensation claims. So essentially, there are a few more components, but I don't want to kind of make this too overly comprehensive for you guys. But essentially, that's what we need to prove. In addition, if you could also prove that the breach of duty, the mistake, for want of a better phrase, by the medical professional caused you, for instance, in the context of the misdiagnosis of the fracture, it caused you extra pain, discomfort, pain, suffering, and loss of amenity, such as the swollen arm, etc. And you've documented that with your GP, etc. Then we can obtain your medical records and instruct a medical expert to prepare a medical report for them to express their opinion on the balance of probabilities as to whether or not they believe, in their independent medical opinion and view, that what you're saying is correct and that the medical expert has made a mistake. If they have, excellent, we can then proceed to seeking to negotiate a settlement on your behalf. In the example of the misdiagnosis, sadly, in relation to the failing pregnancy example provided to you guys, if you clearly, as a result of losing a child, a fetus, you have now sustained and suffered psychological damage in the form of, say, post-traumatic stress disorder, depression, chronic depression, whatever it may be. If that is the case, and that's you have, as a result of your fetus stroke child being aborted on the grounds of a misdiagnosis in relation to a failing pregnancy, due to, again, the erroneous blood test results. If that has caused you some psychological damage as referred to, and that you have documented it with your GP, etc., and there are documentary evidence to support your contention, then we can obtain those medical records and instruct, once again, a medical expert to prepare a medical report on the basis of a review of the medical records and to provide their opinion on the balance of probabilities as to whether or not they believe the doctor has made a mistake, etc. And then we can go ahead and attempt and endeavour to achieve a settlement on your behalf, in the absence of which we'll then have to issue court proceedings and go through that process and potentially all the way to trial and have a district judge or a circuit judge, or indeed a deputy district judge, consider the matter on your behalf. I hope that's helped. If it has, please do not forget to subscribe. Please also provide your comments on the video. Are there any suggested videos you'd like me to do in future on any area of law potentially? Please also give it a huge thumbs up and don't forget to smash that bell icon to receive notifications pertaining to future videos and vlogs. And until next time, F.S Law Solicitors, located in Chadderton, Manchester. The name you can indeed trust. Do take care.